unless prescribed.
Yes.
So why were you still using marijuana?
I have recently started seeing a therapist and my regular doctor to try to get this under control. The night of Easter Sunday, I almost got into a physical altercation with my stepfather, and I chose to step away rather than escalate the situation. So I do apologize for that.
No, and that's great that you stepped away.
5 cases, 1 courtroom, 1 judge who is not playing games. We've got a mother whose kids are racking up absences while she blames a car accident. A woman who drank 10 whiskey sours and then backed into a light pole at 3 a.m. and still refused the breathalyzer. A man who was told no drugs and chose Easter Sunday to light up anyway. A woman with a liver transplant who is still putting substances in her body, working in a medical facility with controlled substances at her fingertips. And a woman who tested positive for cocaine, skipped drug tests, and then stood in court and said she's getting better. Every single one of them has an excuse. The judge has heard them all. Let's see who walks out free and who walks out in handcuffs.
All right, so let's go on the record in the matter of the City of Riverview versus Maya Buchanan, 26320.
Your Honor, good morning. Richard T. Serrano, P3828, appearing on behalf with my client, appears to my right. Your Honor, this is the date set for her arraignment pretrial. Ma'am, please state your name for the record.
Maya Buchanan. All right, and good morning. It's you picking her up, Alicia?
I am, but a little louder, please.
Okay, thank you. Okay, and so today is the date scheduled for the arraignment and free trial in this matter. And counsel?
Your Honor, I've had an opportunity to speak to my client and advise her of all of her constitutional rights. She signed a form regarding that, as well as I've advised her of the nature of the charges pending against her. She understands. Thereby, we waive formal reading today. Ask for a plea of not guilty to be entered for arraignment purposes only.
All right. So please raise your right. I'm sorry. We'll waive the formal reading, enter plea of not guilty for purposes of the arraignment and as to the pretrial counsel.
Your Honor, I'm happy to report that my client's children are back on schedule, regularly attending school. She waived formal reading and as I said earlier, but the pretrial could be that she will admit responsibility to the amended charge of truancy. So make sure what that means. She may need some time to pay fines and costs, Your Honor. If that's accepted by the court, the original charge will be dismissed on the prosecutor's behalf.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And ma'am, you heard the plea of the amended charge that was placed on the record, correct?
Yes.
As to the amended charge of truancy, how do you plead, responsible or not responsible?
Responsible.
And as to your advice of rights, you've gone over those with your attorney, correct?
Yes.
And you understand all of those rights. You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
And you understand as well the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yeah.
Knowing all of that, do you want to continue with your plea? Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please.
Still infraction.
Well, I know, but I think in this case, I'm going to have you voir dire your client just because of the number.
All right.
That's an issue here.
All right. Ms. Buchanan, you have 2 children, 3 children actually, but the 2 that are at school, that's in this case, what are their names?
Alice and Shirley, far away.
I'm sorry. I need you to speak up a little bit more loudly, please. Hold on just a moment. Only one of us can speak at a time. So please speak up more loudly and then spell your children's first names, okay?
Alice and Shirley, A-L-L-I-S-O-N. It's P-G-R-A-R-D. Carter White, K-A-R-T-U-R-W-H-I-T.
Okay, thank you.
And what are the respective ages of those children?
Alice and Shirley, 9, Carter 8.
You're their biological mother, correct?
Yes.
And they're in school, correct?
Yes.
And there were some problems we discussed at length. Your car was in a total accident and you had to pay $10,000 out of your pocket to get it fixed. Is that correct?
Yes.
It took a while, didn't it?
Yes.
Therefore, the school was kind of getting impatient that your children were being late, or in which case you told me that sometimes when you worked, your mother would have to drive them and pick them up and she wasn't always timely. Is that correct?
Yes.
I've explained to you that they're your biological children. they ultimately are your responsibility. You understood that, correct?
Yes.
And now they're back on track because your car is back, correct?
Yes.
Even though you're working two jobs, both nursing home jobs, you still get some help from your mother occasionally. Is that right still?
Yes.
All right, but generally now their attendance has improved. Is that correct?
Yes.
Back on the right track, even though in the past there were some pretty big numbers of lateness and or absences. Is that correct?
Yes.
These are all related to what the reasons we discussed on the record. Is that correct, ma'am?
Yes.
I'm satisfied, Charlie.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And, ma'am, when did you get your vehicle back?
March.
Approximately.
February 19th.
Okay, since you've had your vehicle back, have the children been late or absent at all? Okay. It's a big number. That was a big number of tardies and absences.
It wasn't absence. It was like 30 minutes early from they. It was like 30 minutes picking them up, 30 minutes early from school. So it wasn't like they was missing school.
They were missing the whole day. They were missing the last 30 minutes of instruction.
Most of the time, yes.
Okay, but it was recess. It was like they would be outside on the playground and they would get picked up. It wasn't like they were in a court class.
Okay. All right. And so, so that's all been resolved now that you have your vehicle back.
Yes.
Okay, very good. All right. The court's going to order a $50 fine. Do you have that to pay today?
Yes.
Okay.
In my car.
Of course. Yes. All right. Okay. So just so you know, ma'am, originally you were facing a much higher fine in court costs. And even with the truancy, it could be a higher fine, but I reduced it to just one $50 fine. Okay. Have a good day. Have a good day.
Thank you very much.
Thank you. All right, let's go off the record. Let's go on the record in the matter of, good morning, council, in the matter of the city of Riverview versus Cassandra Jensen, 26314 A and B.
Your Honor, good morning, Richard E. Solano, Pete, 3828. Your Honor, today I appear as MIDC counsel on behalf and with my client who appears to my right. And this is the date you have set for her arraignment. And would you please state your name for the records for me?
All right, and so today is the date scheduled for the arraignment pretrial in this matter. And as to the arraignment counsel.
Your Honor, I've explained to my client the nature of the charges. Well, from this administrative agency, she understands those charges, and also she's been advised of her advice of rights. She has signed an advice of rights form regarding that. So as to arraignment, Your Honor, my client waives formal rating stands, and you let me ask for a plea of not guilty being for regular purposes.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then as to the pretrial.
As to pretrial, Your Honor, after meeting with the prosecutor, my client was to avail herself of the offer and that she will plead guilty to the amended charge of operating a motor vehicle while visibly impaired by alcohol. She understands what that entails. If that's in fact accepted by the court, the original charge of OWI would be dismissed in addition to the civil infraction of a preliminary breath test refusal. And we're ready for the court's examination.
All right, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth. All right, and you heard the plea that was placed on the record, correct?
Yes.
Oops.
Yes, ma'am.
Ma'am, I need you to speak up more loudly, please.
You're right.
Okay, I need you to speak up more loudly after I'm done speaking, so that you, only one of us can speak at a time. I understand that you're nervous, but just please wait till somebody's done before you respond, okay?
Sorry.
All right, so your name again for the record, please.
Cassandra Jensen.
Is that better?
Mm-hmm.
Okay, thank you. All right, and so ma'am, you heard the plea that was placed on the record, correct?
Yes.
All right, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
I do.
All right, and you heard the plea that was placed on the record.
Yes.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
And you just speak up, please.
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes, I do.
You also understand by entering into a plea that you'll be waiving some of those rights.
I do.
You understand as well that the possible penalty as a result of your plea, whether in this court, any other court or administrative agency,
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
All right, counsel, if you can please order your client.
Jensen, on or about February 14th, 2026, it was early morning, about 3 a.m. Were you operating a motor vehicle in the city of Riverview?
Was.
Prior to that, operating that vehicle, had you consumed alcoholic beverages?
Yes.
Could you please tell the court approximately how much you had to drink and how many over what period of time?
Probably 2 hours and I had probably 10 whiskey sours.
Those contain alcohol, correct?
They do.
Where were you drinking?
It's did not work. I don't remember the name of the place, but it was on the street.
Yeah, it was a bar of some type. And then you operated your vehicle, correct?
I did.
And you had a minor accident in that you backed into a light pole or phone pole. Is that
I
correct?
did.
Police responded, right?
Yes.
Upon the officers investigating the situation and talking to you and the like, there came a point in time where you were offered a preliminary breath test on the scene. You did not take that. You refused it. Is that correct?
Correct.
Subsequent to that, you were arrested, right?
Yes.
Okay. And you were taken to the Riverview Police Station.
Yes.
Do you recall taking a breathalyzer? You recall being there?
I was there. Yes.
All right. And if I told you that your results were 0.122, your blood alcohol level, you told me you would agree with that in the office. You still agree with that?
Yes.
I can't hear you.
That's it. Yes.
And finally, do you believe that the operation of your motor vehicle was affected by your consumption of alcohol in that you ordinarily don't drive and hit poles? Is that correct?
No, I don't.
Did the alcohol contribute to that?
Did.
I'm satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charges per the plea agreement. And, counsel, if you can please order your client.
I did.
I'm sorry. I'd speak to mine.
Bond?
Yes.
Okay. My client tells me she's divorced. She lives presently with her mother. She collects Social Security disability. That's been about 2 years now. She's not on probation or parole, never failed to appear in court, she's told me. And nothing else pending, Your Honor. So we asked the court to consider a personal bond. You didn't post any money yet in this case, did you, ma'am?
No.
All right. We leave in the court's discretion.
All right, ma'am, if you were to test right now, what is in your system?
Nothing. Nothing.
Have you ever failed to appear in court for any reason?
No.
Are you on probation or parole anywhere? All right, the court will order a $5,000 personal bond. You're not to possess or consume any alcohol or drugs unless prescribed. Please have a seat in probation. You'll get a copy of your bond conditions and all of your next steps, okay? All right, good luck to you. All right. All right, let's go on the record in the matter of the City of Wyandotte versus Devin Durham, 2680.
Good morning. Dave Short, prepared on behalf of Mr. Durham, standing question.
Good morning, Your Honor.
Good morning.
Record, please.
Durham.
Thank you.
All right, thank you. And thank you for addressing appropriately for court. Today is the date scheduled in this matter for sentencing on your client's plea to an amended charge of operating while visibly impaired by alcohol. And counsel, do you have an opportunity to review the report and recommendation with your client?
Yes, we've both gone over it. I sat down with them this morning. The contents appear to be correct and accurate. We're asking for no regulations.
Okay,
Your Honor, I believe the recommendation of probation department to be a reasonable one. I've gone over that recommendation with Mr. Durham. We respectfully ask the court to simply adopt that recommendation.
all right. And so, sir, you don't have a medical marijuana card. And when's the last time that you consumed any marijuana?
Easter Sunday.
Okay. Which was after you were arraigned in this court.
Yes, ma'am. Yes, Your Honor.
So I ordered on January 28th not to possess or consume any alcohol or drugs unless prescribed.
Yes.
So why were you still using marijuana?
I have recently started seeing a therapist and my regular doctor to try to get this under control. The night of Easter Sunday, I almost got into a physical altercation with my stepfather, and I chose to step away rather than escalate the situation. So I
Okay.
do apologize for that.
No, and that's great that you stepped away. But if you need marijuana to calm you down, then that signals that potentially there's an issue with that. Further, you don't have a prescription, nor can you just go get a medical marijuana card from a medical clinic doctor without having anything coming through this court.
Understood. That was not my intentions.
All right. Moving forward, sir, if you're using marijuana and it's showing up in a test, that's going to be a violation.
Understood.
All right. So I'm going to indicate that you have admitted that your last use was April 5th, which was Easter Sunday. So that when on your first test that's going to be done, you will likely still show some in there, but there should absolutely be a declining value in the subsequent tests.
Yes, Your Honor.
Okay. So counsel, if you have to chat, Ms. Tucker, if you have to chat with your client, if you can please go in the lobby.
Oh, sorry.
That's fine. All right. And so, Mr. Durham, anything else you'd like to say to the court today?
No, Your Honor.
All right. Anything else, counsel?
No, Your Honor, thank you.
All right. The court will note after hearing from counsel and from Mr. Durham and reviewing the report and the recommendation, the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Durham and the legislative guidelines. The court's going to order 12 months probation. You're eligible for early discharge, which I will go over shortly. You are not to violate any criminal law of any unit of government. You are not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. Do not use any alcohol or drugs unless prescribed and be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining absence and sobriety. I am going to have you tested today, so we have a baseline level. All right. You are to participate in the chemical awareness program. The rehabilitative goal for that condition is so you can further educate yourself regarding drug and alcohol use so you can make better informed decisions in the future, hopefully preventing this matter from happening again. And then you are to attend the MAD Victim Impact Panel. The rehabilitative goal for that condition is so you can further increase your understanding of the dangers of driving while under the influence and the consequences of such behavior. Any questions regarding those conditions?
No, Your Honor.
The court's going to order a $300 fine, $100 screening assessment fee, $600 supervision oversight fee. That's $50 a month at 12 months. And since you're eligible for early discharge, up to half of that could be waived. Excuse me, $300 for the cost of prosecution. Crime victim assessment fee of $75. Justice system assessment fee of $50 for a total of $1,425. But you can set up all your payment plan with probation after applying your bond. The court, do you have any questions regarding any of those conditions?
Okay.
All right. As I did indicate, you're eligible for early discharge as long as all of the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment.
Okay.
All right.
Your Honor.
You're welcome. Good luck to you. Please stop at probation for all of your next steps.
Thank you.
Have a good day.
Your Honor. Have a nice
You're welcome. Thank you. You as well. And then let's go. You doing okay, Alicia? Okay. Let's go on the record in the matter of the state of Michigan versus Cheryl Shabani, 241258.
Morning, Your Honor. Dr. P. 5402.
Thank you. Ma'am, your name for the record, please.
Cheryl Marie Shabani.
Okay. And so today is a date scheduled for sentencing on your client's plea to an amended charge of attempted possession of controlled substance and as well as driving a license suspended and operating without security. So counsel, the first question I'm going to ask, when I was reviewing this report, is your client interested in treatment court?
So basically it's a different kind of probation. They give you counseling, they give you substance abuse treatment, but you would still be under probation.
Right.
It's a little more intense. So instead of you doing it all on your own as like what probation is recommending, you go do all of the outpatient and all that stuff yourself with the drug treatment court. They help facilitate all of that.
And you have a lot, you have a lot more support. And I asked that, counsel, because given that your clients had a liver transplant and that she's still putting all these substances in her body, tells me that she needs a lot more support and direct supervision than what's currently happening.
I could do that. Yes, ma'am. I mean, but I think she would benefit from that to help her stay alive. I do have an addiction problem. Yes, ma'am. And I really use a lot. I'm getting help now, but
Well, I'm glad to hear that. But I will also indicate one of my concerns is that given that you work in a medical setting, right, and you have substances controlled or otherwise, right, all available at your disposal, I have other concerns.
a lot of sense. Yes, ma'am.
Well, thank you. I'm glad that
I mean, it's
somebody thinks that makes sense some of the time. Okay. So then what's that?
requires it.
Your Honor, she did bring in too that the proof that she's been testing since
Okay.
her bond violation.
Okay, Bobby, can you show that to me? Can you grab that for me, please? Thank you.
And I don't know if the court wants to see, she did get a letter from her doctor also.
I'll take
Going to,
a look at that as well.
and then she brought some information, I guess her kidney function is declining too, so when she does the drug testing, it doesn't filter out as fast, as, it would if say if it was near you with normal kidney function.
Okay,
So,
so let me ask this question. Before I get to that. So, ma'am, is this Dr. Otto your treating physician?
He's my primary care physician.
Okay, all right.
Doctor.
Okay, so,
and he's filling out the paperwork for her for the marijuana, she just has to pick it up from.
He's already.
well, just so you're aware, for this court, this letter would be sufficient, but for treatment court,
I'm gonna-
you may have to have the card. So what I'm going to do, is I'm going to, indicate that we're not going to hold the sentencing today. We're going to do a referral for you to, the drug court. Okay, that's going to be at the 25th District Court unless they're full. And then there's another treatment court, then counsel, you can help your client, facilitate that screening there.
Thank you so much, Sharon.
Okay, so what's going to, well, tell me about these, warrants that you have.
So she said, when I discussed, she said she's taking care of the one in Port Huron. I definitely took care of, and those were like a long time ago.
Okay, so let me,
So I'm assuming those were the warrants, but it's also say criminal history, if it's other warrants, they're not listed in it,
right, I'm going to look at those real quick for you. All right, so I'm showing, Allen Park from 2018 for driving while license suspended. Clinton. I don't think that's Clinton Township. I think it's Clinton. So out there over by like Irish Hills, maybe.
Port Huron, like in that area.
No. Irish Hills is west. Port Huron is north and the south. Okay, it's 41B District Court. So, suspended operator's license. Then there's one in Dearborn. That warrant's been since 2008 for driving while license suspended. And then also out of the 25th District Court from 2015, the license has been suspended. And that's a moving traffic violation. So those are where the warrants are. So not Port Huron.
Okay.
Okay. So, ma'am, all cards on the table. How'd you get here today?
I got dropped off with a friend. She's actually gonna pick me up and drop. I swear, I am not driving.
Okay. All right, bond and conditions are continued. I'm going to give these documents back to you. And then I'm going to have you go over to probation, and then you can get all of the next steps as far as screening for treatment court, the referral and all of it.
Okay.
And then a new sentencing date. Okay. All right, so these go back to Ms. Shabani, please, and then she's going to go to
She'll come
probation.
back over here for sentencing on 25th if she gets back over.
So if she's referred, deemed eligible, accepted, then she comes here for sentencing, and then we do a complete transfer over.
Okay.
Yes. Okay.
Thank-
All right. Thank you.
Thank you.
You're welcome. All right. Have a good day. All right. Let's go off the record. Okay. Let's go on the record in the matter of Terry Hernandez, 25608.
Great, I do have a boy on behalf of Terry Hernandez. Step up and state your name.
Harry Hernandez.
Okay. Today is the date scheduled in this matter for a probation violation. Your client is on probation for disorderly conduct, which was amended in the more serious charges of possession of controlled substance and possession of drug paraphernalia were all dismissed by way of resolution between counsel at the pretrial. And then your client was originally her plea was taken August 27th of 25. It was originally scheduled for sentencing in October, but that got adjourned based upon your client's prior attorney schedule to November 18th. And November 18th, we did not sentence your client. We conducted the bond violation, but your client was interested in treatment court. But it appears as though when it came time to sentencing that your client, let me see here, was either not eligible or was not interested anymore.
Your Honor, I was interested. The probation lady in Lincoln Park said that it was an overkill for me.
Oh, now I remember all that.
I did try.
No.
I had a very hard time because
Hold on. I don't know why it would have been determined to be overkill, but in any event, I do recall all that now. So, your client was sentenced February 18th, and this, counsel, I'm just going to clarify, right? This is why I felt as though your client would have been a good candidate for treatment court, because while her conviction disorderly conduct, her original charges were drug related, 2 of them. And just because there's a resolution one way doesn't mean that then evaporates the need for somebody's need for treatment court. So in any event, your client is alleged to have had a diluted test February 20th, not appeared for drug testing on February 25th, positive for cocaine March 13th, failed to appear for drug testing March 17th. As to those violations, counsel, how does your client plead?
Please guilty.
Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
And you've heard the plea that was placed on the record, correct?
I did.
And you've gone over your advice of rights for probation violation purposes with your attorney, is that correct?
I did.
And you understand all of those rights, correct?
I do.
And you also understand by entering into a plea that you'll be waiving some of those rights.
I do.
And you also understand, ma'am, that the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency. And that the recommendation in this matter is for probation to be revoked, case closed without improvement, $50 probation violation fee, 30 days jail to be tethered to treatment. Do you understand that's the recommendation?
I do, Your Honor.
Knowing all of that, do you want to continue with your plea?
I do.
Has anybody promised you anything, threatened you, coerced you in any way for you to enter into a plea?
No.
Any, and you understand this would be technical violations 1 through 4 entering, correct?
I do, Your Honor.
All right, counsel, if you can please forgive your client.
Yes, I will. Mr. Hernandez, Isn't it true that you were, you pled guilty to a misdemeanor charge in this court?
I do.
And that, you were placed on probation, the certain conditions of that probation were that you, do random drug testing as ordered by the probation department.
I do. I did.
And also as condition of that probation, you were not to do, or consume any illegal drugs.
Correct.
And in spite of that, there's a report that on, or about February 20th, 2026, a report, your drug test came back as diluted. In other words, it's indication that you were drinking too much fluid.
Correct.
In addition, on February 25, there was a report that you were to appear for a drug test and you did not appear for that drug test.
Correct.
Subsequently, on March 13th, there was a test and you tested positive for cocaine.
Correct.
And then on 17th, there was another drug test scheduled that you failed to appear for.
Correct.
Your Honor, satisfied with that.
The court is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violations, technical violations 1 through 4 will enter. And here's what I think should happen. Another referral to treatment court, because that can't, probation violation can be a conviction by which that can be referred to treatment court. You're early enough in to your probation now that I don't see time being a barrier for the program. And I say that because the maximum amount of time in a program for district court is 24 months. So you're only about 2 months in. So I think that would still be sufficient time for you to complete the program.
Yeah. Your Honor, I worked really hard to try to get inbound claim, and I'm denied several times at several different places. I've emailed all the times to get that call. I finally got involved in the guidance 7. I lost my daughter 7 years ago, Your Honor. I deal with a lot of depression. There's days that I don't want to get out of bed. And I believe that I mispass, but I do want to change. I'm not in denial about the mistakes that I've made, the things that I've done. I do work. I take care of an elderly lady who's 88. She's deaf. I volunteer my time in charity church. I did do my community service. I am going to them classes once every third Thursday.
The fan meetings?
Yes, I'm not in denial on any of this. I honestly trying, and I'm getting better. I'm getting better each and every day. I changed my antidepressants from Zoloft to Cymbalta. I feel better on that. The last child was a very severe loss. My daughter was ill. She was ill all her life. So I'm glad she's wrapped in her peace. But it's still a challenge.
Of course it is.
Just to get up and deal with the days like living.
Of course it is.
So
Of course it is.
I have struggles, but I am going to get better, and I'll show that to you. I am getting better.
Okay.
I just want to do everything I'm supposed to do in the proper manner and change my lifestyle.
Well, and I do believe that treatment court will be a huge benefit to
I'm
you.
sure it will.
Which is why I suggested that previously.
Right.
But perhaps because the conviction of disorderly conduct and that you only had one other prior conviction, you didn't have a significant criminal history. Maybe that's one reason why it was suggested as overkill. But I mean, when there is an addiction issue, in my opinion, it's not overkill at all, no matter what the conviction is.
I see.
All right. So I'm going to order a $5,000 personal bond. I'm going to have you go over to probation so you can have that referral done. And then we'll have you come back for sentencing on the probation violation. Okay.
Okay. Thank you, guys.
You are welcome.
Will you leave her?
Yes. Go on over to probation.
Oh, she did it today. Okay, very good. Any questions?
No.
Okay. Take it. Thank you, Your Honor.
You're welcome. All right. All right.
5
We're
defendants, 5 chances. This judge didn't scream. She didn't have to. She let the choices speak louder than any sentence could. Treatment court, personal bonds, reduced fines. She handed out second chances like they were earned, not guaranteed, but second chances only work if you choose to use them. So here's the real question. When the system bends over backwards to help someone, and they still relapse, miss tests, and make excuses, whose fault is it next time? Do you think the judge was right, or did these defendants waste their final chances? comment below, hit like, and subscribe for more real courtroom breakdowns.